Hello and welcome to Unleashed, the show that explores how to thrive as an independent professional. I'm your host, Will Bachman. Today we have with us Dan Weiner, who's a partner and founder of the firm Schaefer and Weiner, a restructuring law firm based in Bloomfield Hills, Michigan. The firm's 35 years old. They handle national and international restructurings. They have 10 attorneys. And Dan himself has 40 years of restructuring experience. And I'm so excited to have Dan on the show today. We're going to talk about both restructuring in general, what are the options, who's eligible, what does it mean? And then in the second half, we'll get more specific and talk about what's the implications in the age of the pandemic. So Dan, welcome to the show. Tell us, just help me understand if someone doesn't know at all the term restructuring, like me, somewhat, tell me, what does restructuring mean and what are the options, who's eligible? Just start giving me an overview.
Well, Will, thanks very much. It's an honor to be on your show and very much appreciated. Uh, it's certainly a broad topic, but I'm going to try to narrow it and give some helpful hints and perspectives on what to do. When you have a business that or an individual that is experiencing distress. And the real key to start when clients will come here, you have to understand as best you can quickly the root cause or causes of the distress. Is it something specific? Is it something that you can point your finger at? Is it a trend? Is it a business that still wants to try to make a living making rotary dial telephones? Or is it a business that had a bad quarter or had issues that you can point to and look at them and say, there is a core business here. And this core business has challenges, but we can help to fix those challenges and restore value to the business. So the point in the very beginning is really to understand what the causes are. And that requires some intuitive experience. It requires document review. It requires interviewing in person management, so you can look at them and look in their eyes and watch their body language and understand what they're telling you, because what they're telling you is not always what's going on. So you have to be a bit of a detective and an analyst and actually a psychologist in many ways to understand what's going on and get management to tell you, and so that you can understand what your alternatives are. Um, there are times in terms of identifying what to do. Clients will come in oftentimes and say, Dan, I need to see you. I need to file a bankruptcy for my business, or I need to file bankruptcy for myself. And I look at them and ask them why they concluded that. And of course, they're not really sure. And the point here is that a decision to restructure, or either in court or out of court, or filing, is a conclusion. It is not the first question. It's very much like, I'll use a medical analogy. I hope it's still appropriate, where someone goes to the doctor and says, "Hey, doctor, I'm not feeling well, and I think I need surgery." Well, the doctor says, wait a minute, hold on. Let's figure out what's wrong with you. Let's run some tests. Let's do a blood panel. Let's do an EKG. Let's do a history. And maybe you need surgery and maybe you don't. Maybe you need a bankruptcy. Maybe you don't. Maybe you need a filing. Maybe it's out of court, consensual restructuring. So we have to get to the issues of why the business is where it is.
Yeah.
And
So,
yes,
so you've seen hundreds and hundreds of these cases. Dan, let's talk just a little bit more about kind of the range of potential root causes. You gave a couple examples. Your products are obsolete, or you had one bad quarter, maybe one big customer went bankrupt and failed to pay you or something. But could you give us a more sort of comprehensive list of the types of root causes that you think about when you're doing a diagnostic?
Sure, sure. Well, one of the key issues in any business, of course, is management. Management's ability to execute, management's style, and management's talents. That's always a tough thing to talk about because many businesses come in and the guy who's running it or the woman who's running it says, "I'm doing a great job." That's always tricky. But it starts with management. Sometimes it's management's inability to execute, management's decision that there's money on the table. Let's not put it away for a rainy day. Let's just take it out of the business and have no safety stock of cash and no safety stock of anything that will be necessary in a downturn. Sometimes a customer loss, major customer leaves. That's an issue that comes up very often. Many times expenses. Family winds up on payroll more often than is healthy for businesses, especially when they're not really doing anything. So we have that issue. Sometimes we have a lender. The lender, let's talk about a business that's doing fine. It's within its covenants, it's paying its debts, and everything is fine, and the term is coming up, and the bank says, we're changing our portfolio and our concentration, and our analysts say that we're moving out of this sort of sector. They don't say it exactly that way. They come up with some different verbiage, but the point is that sometimes you're doing fine and the bank says, we're not renewing. And that's of no fault of the business. So we have all kinds of issues. Some have to do with the business's failure to be profitable, and some are totally external that are totally beyond the control of the business, like the lender situation that I indicated. And sometimes it doesn't give the business enough time to pivot and understand that just because the lender extended the loan 3 times, all of a sudden, the 4th time the lender says, not going to do it. We'd like you to find another bank.
Okay.
So the reasons, the reasons are, every time you think you've seen it all, you realize you haven't seen it all. It's dynamic and it's fluid, and you just have to be able to understand that the clients that come in will have, sometimes it's same old type story, and you say you've seen this 100 times before, and some will come in that you've never ever seen. So you just have to be a really good listener, a really active listener, and understand what it is that the client needs, even though the client can't articulate what it is that it needs.
So you go in, you do a diagnostic, you try to understand what the root cause of the distress is, and then walk us through what some of the kind of options are that are on your mind that you think about that a business could potentially take if it's in distress.
Well, notwithstanding that we are very active in the Chapter 11 filing world, my first instinct is to understand whether or not we can identify the issues and fix them out of court. Now, you can't always do that because sometimes the pressures on the business are such that that's not an option. For example, if somebody comes with a multitude of litigation that pending against the business in different courts, different states, and it's simply untenable and too expensive to defend those cases. Sometimes you'll find them in asbestos cases. Sometimes you'll find them in other tort cases. Sometimes you'll find them in retail scenarios. Sometimes there are things that that impact the business that are not economic to try to fix out of court. Sometimes you can still do those. We've certainly done our share, but the question really comes up when you look at this is what is the what would be the plan that you could use? Who do you talk to? In what order? Who do you negotiate with? What are your goals? What pieces in place do you have to have? And the order that you have to do those. So when you look at that scenario, you try to figure out, at least what we try to figure out is there a basis to reach a consensual plan that is typically far more efficient and cost effective than an actual filing? And you might think, or people might think, well, you know, if it's a bigger business, you can't do an out of court. That's not really true. We've had the experience of trade debt $25 or $50 million or more with out of court successes. So you really have to understand who the constituents are, where the pressure points are, what the agendas are, how do you go about contacting those constituents, and with what approach and in what order. And before you can do that, in any case, you have to understand the documents. You have to understand the lenders. You have to understand what the rights of the creditors and what rights you have. And you have to be able to start with that right away, because it's a hell of a time to figure it out later. You better do it from the get-go, because you do it once and you do it right. The situation will then determine which way things can go. One of the benefits of actually the bankruptcy code, that it's a very mature statute by now. The most recent major code was changed in 1979 and then later in 2005. And some other amendments. But the key here is, if you've worked with the bankruptcy code sufficiently, you can understand, you've seen the movie, you've been in court, you've litigated the cash collateral, you've litigated the DIP financing, you've litigated the discharge, you see the movie many, many times. And even though things are still different in any particular case, you can take the experience from the filings of the cases and use that experience to mimic an out-of-court process. And in other words, you use the bankruptcy code as a tool when you can, rather than an actual filing. Sometimes you have to file, but in many situations, it is worthwhile for the client to be able to go about a restructuring as if there was a filing, but not an actual filing, because you then know what's going to happen in the filing pretty much, or at least you have a good idea of it, and you can use that to negotiate and leverage where necessary the creditors and the constituents that you have to solve by consent rather than by court order. So that's where there's the science of the bankruptcy code, and there's the art of the practice, and that's where science and art really come together and mesh very well together with the experience of the actual filings over all of these years.
Okay, great. So Dan, I learn best with like real tactical examples that help illustrate the case. So perhaps you talked about figuring out, you know, what the plan is, who you need to talk to, in what order, and what kind of conversations to have. Let's take a case of doing restructuring out of court. Could you maybe sanitize an example of a company that you've worked with to help give us a real tactical sense of what it looks like, and sanitize the company obviously, but walk us through a case where what's the situation, and then who would be the vendors that you'd talk to, or the creditors or the suppliers or customers, and what kind of conversations you have, in what order, and then is it like renegotiating lease terms or renegotiating payment terms, and just sort of walk us through an example.
Yeah, that's a really good question, and there's one on the tip of my tongue actually, because I'm in the middle of doing it right now, and of course, I'm a big confidentiality observer, and the names of the innocent shall remain anonymous. But I can respond to your question. I think very accurately. We're in the process right now of doing an out of court restructuring of a snack food company. The snack food company used to be very successful. It now has millions of dollars worth of debt and little inventory and little receivables, but it has a brand, and it doesn't have a lot of cash at the moment, but it's getting better. But the approach in that kind of situation was, first of all, you have to understand what rights the bank has. And we started with doing an analysis of the rights and the extent of the rights of the lender, what collateral they had, what collateral they didn't have, whether what they were perfected on, what they weren't perfected on. Were they a big bank? Were they a small bank? So we started with the lender because obviously there was collateral and we had a secured creditor, and that's where we started first. And what we did with the lender was we created a very strong channel of communication, and transparency, critical to lenders. We had a maturity default, and we did an in-person meeting with the lender with a lengthy presentation explaining the history, the present, the future, the ask, and what we needed. So the first thing we did was be able, after some fits and starts, some weren't fun with the lender. They took some aggressive action along the way, but we were able to negotiate a deal with the bank. That was really the first thing, because if the bank was not going to negotiate and was going to enforce their remedies on default and seize collateral, we wouldn't have had much of a choice but to file and obtain the benefits of the automatic stay and deal with them in the Chapter 11. But we were able to do a deal with the bank. And part of the deal with the bank mimicked some of the things that we would do in a Chapter 11. And the bank saw the positivity in that, and we signed a deal with the bank. Now, the next thing we needed to solve, and it's not like we weren't thinking about it at the same time, but we now had millions of dollars of trade vendors that had cut us off, or maybe were CIA, cash in advance, maybe COD. But how are you going to de-lever the balance sheet with these creditors? And what we did with the creditors is we did a very simple out of court. First of all, we went to the whiteboard, which is, should have said that in the beginning. The whiteboard is my best friend. It scans, it prints, I have color, it downloads to sticks. And it's a great way, at least that we've designed solutions. I'm sure many of you out there know exactly, are smiling because you do the whiteboard as well. In any event, we came up with an approach with the creditors, and it wasn't a 50-page agreement. It was a total of 3 pages, one maybe 2 pages. One was the summary of a turnaround plan, and the other was a ballot. And we circulated that, and we thought very carefully through what options we wanted to provide to the creditors and where we wanted the creditors to go. And we relied on some of the experience and classification of creditors under Chapter 11 and decided what we wanted to accomplish uh, with the various creditors, depending on how important they were to us. So we sent out this very small package to our creditors, and creditors are voting on those issues. Another constituent that we have to solve was the landlord. And of course, not surprisingly, we were behind on the landlord. Now, if we were going to be in Chapter 11, we would not have paid the past due rent. We would have dealt with it later. But in the case of trying to stay out of court, we decided to negotiate with the landlord and bring in some fresh capital and catch up. We saw what we would do with them in an 11, but an 11 was more expensive. So we solved the landlord. You had to pay the landlord, but that's pretty critical space, and it was a very good lease for us. So and moving was not much of an option. So now we solved the landlord. We also have an equipment lender that has a bunch of the equipment that the first bank was not secured on, and some of it's pretty critical. And we are again using some of the principles of the code to negotiate with the equipment lender and de-lever the balance sheet, buy some time. And part of our negotiation with them was, hey, you know what? When we get back on our feet, we need new equipment. Tell you what, you're going to get first look and last choice when we go to a vendor, because we remember who our friends are and who helped us. So with one eye, you have to look at the past, and with one eye, you have to look at what's going to motivate somebody to want to do business with you going forward. So where all this is right now is this business, I'm cautiously optimistic, it's going to get back on its feet. We're actually starting to get credit. And part of the issue happens to be, and this is simply unplanned, the food industry, because given what's going on today, food and grocery stores have, are essential. And while snack foods may not be as essential as bread, depending on what your diets are, and maybe you'll think snack foods are more healthy than bread, but whatever your dietary view is, there are actually suppliers that are hearing that we're getting back on our feet and are calling to say, would you consider buying from us? We might be willing to give you some credit. So in any event, so far so good with that. We have still many things to solve, but we have the major constituents under control, like we would have to do in an 11 anyways. And the good news is the bank was willing to deal with us. We didn't have 15 or 20 lawsuits pending out there that even if you solve all but two or three of them, if two or three of them go forward, with a lot of expense, it's not very efficient to defend them. So hopefully that answers your question of an example of how to go about orchestrating a reorganization, in this case, so far out of court. And I'm fairly confident we'll be able to continue to achieve that as the creditors hopefully continue to support the company.
Okay, that's a really helpful overview and a great example. Help me understand it. Maybe we could turn now to situation of a lot of business owners today, which is maybe a little bit different than sort of your run-of-the-mill cases where you're trying to do this root cause analysis. In this case, there's hundreds of thousands of businesses where the root cause is pretty straightforward. The business was going along fine. Restaurant owner, bar owner, nail salon, yoga studio, gymnasium, and boom, all of a sudden, the state has just told them to shut their doors. So for businesses like this, where we know the root cause, walk us, and these might be smaller businesses, maybe than larger manufacturer, what are some of the options that a business like that should be thinking of, like a business owner who owns a restaurant or a bar? They may have some debt. Maybe the restaurant owner took out some debt to kind of furnish the restaurant. That debt may be, they may be personally liable for it. Even if they have an LLC, they may have personally signed against it. What are some options for the owners in those situations?
Yeah, that's a very, very good question, and I will do my best to answer it because I have some ideas and some approaches. But anybody that tells you they know how all this is going to come out is delusional. Because talk about situations that is not the cause of the business. This is just this is not sector related. It is not. It's not the auto supply chain rationalization in the late 80s and 90s and later. It's not the real estate recession in 07, 08, and some of the financial issues that happened. It's a broad swath of across everything, and everybody is trying to react with the flow of information that changes by the hour or even less. But having said that, there's as serious as this is, if you think through some approaches and use them, I think you can put yourself in the best position for these types of businesses as possible. First of all, just for the listening audience, and some of you may be familiar with this, some not. There are some legal principles here, and then I'll talk about the restructuring piece. But before we get there, you'll hear some terms out there that are apropos. Many times you'll hear the phrase force majeure, the superior force. A force majeure is sometimes they're in contracts and sometimes they're not, but essentially it's a concept that allows a business to claim a defense for breaching a contract because of something totally beyond its control and nothing that it did wrong, and things that just make it absolutely impossible. Sometimes it might be a tornado, it might be an act of God, it might be a natural disaster. I think today, if this is not force majeure, then nothing is. It is a poster child of force majeure. So this is impacting many businesses. There are also statutory similarities under the Uniform Commercial Code with impracticability of performance and things like that are putting businesses in default through no fault of their own. Now, if the business was already in big trouble and this happened, it's not the same. This is something that is sort of taking. I'm focused on the situation where businesses are getting along fairly okay, give or take, even bleeding some cash, but this makes it very, very difficult to respond to. So, with that little bit of background, what do you do today? I have a particular thought about it, and it's sort of honed just from the experience of dealing. Our practice is mostly debtor side. Once in a while, we'll represent a secured lender, but please don't tell anybody. We like to keep that quiet. But it pays bills. So the fact of the matter is that when you're representing a debtor, I have some hotel clients, okay, highly leveraged hotel clients, or mom and pop, much smaller operation. Doesn't really matter. Um, the approach that I like here is to distinguish our clients and my approach from others that just might say, "Oh, you know what? The whole world is upside down. I'm not I'm not able to pay anything," and they just stop paying and they don't reach out to their creditors and they don't reach out to their lenders. And that may work for a while, but when all of this gets, but what's going to happen is when the curve catches up, and the assumption that no that yeah, lenders have their hands full, which they do, but that's not a good approach. I think the idea here is, and what we're advising clients are, you know what, be proactive. You reach out to your lenders. You make the call. You write the letters. You explain the situation. You be the architect of an approach, because that way you're a good corporate citizen. You're responding. You are showing that you acknowledge your obligations, and and you get out ahead of it. And you might come up with an approach, and that's a customized, situation with any particular major supplier or lender or landlord or whomever that you have ongoing obligations to, which is pretty much the world, on a regular basis. And if you go about it that way, you're going to put the ball in the lenders or the creditors or the landlord's court. And when you do that, you look good. You're trying to help. You're trying to be proactive. And if it turns out that the lender or the landlord or the creditor doesn't know what to do, and can't respond, or is itself unclear, and there's delay, you've put it out there. So when it comes time to be in a courtroom, or it comes time when to deal with this issue, when things get back to normal, you have demonstrated that you are different than some others that simply look at this as a payment holiday. So the communication, just like the real estate people, location, location, location. It's what it's all about. And if you do that, you'd be surprised the forbearance and cooperation and the breathing spell that you can get if you go about it the right way.
So help us with some of the language. So let's say we have a restaurant owner and has a lease and has refurbished the place when they set up the restaurant, so got a loan for that, for all the fixtures and redecorating and so forth. So they have maybe a bank lender, they have a landlord, and perhaps I don't know if restaurants typically will get terms from their suppliers of raw food and materials. So three main groups, right? So what would you advise that kind of client to talk to the landlord about in terms of what offers? I mean, if you say, hey, my restaurant's been shut down, the doors are shut altogether, or maybe it's a bar, so they can't even do takeout. To the landlord, would you say, look, can I just not pay rent until this thing passes and my doors are open again, and then we can increase the rent when we reopen and I can pay that 3 months back over a period of 3 years, or like what would sort of a reasonable thing to say be to the landlord? How would you advise a client to negotiate that piece?
Um, and Another good question, and of course, it's all fact dependent. But you're looking for maybe a generalized approach, and some common concepts to think about. So let me try to address that. I think it's key to understand uh, the difference between rent and that you pay to the landlord and the operating expenses that the landlord has to its utility companies, its the water, and the expenses that the landlord has to pay, whether regardless, depending on your lease may say that the lease may be triple net, but that's your obligation to the landlord. That has nothing to do with the landlord's obligation to the utility companies. So one thought is to distinguish between rent and expense, and rather than just say I can't pay anything for 2 months, um, there's a better approach that the landlord's going to say, you know what, this business is thinking and it's trying to come up with something that is not strictly a payment holiday. So sometimes it's a combination of that. Sometimes it's a combination also of you understand the timing that what a landlord is going to have to do to process an eviction proceeding. And although courts, at least, I can't speak to every state, but right now in Michigan, as in many other places, everything's by telephone. The courts are open, but they're open telephonically. They're not open in person. Now that may differ in critical criminal matters. It's not my area. So, but in the civil arena, um, there are delays that are built in already because of docket issues and court clerks working at home and all of that. So the landlord approach may be a combination of that plus a deferment, and a restructuring of the lease. The permutations and combinations are unlimited, and it really depends on, is the business seasonal? Is the business going to have, is it a business that come July 4th, and hopefully this is all over well before that, but are there liquidity events that the company can reasonably, hopefully, point to, and to tie some of the obligations that have been deferred to those, or simply a lease modification. And it's sort of a complete mixed bag of concepts, but I think I would start with the rent versus cost approach, and then feather in the rest of the proceedings as necessary. I think also what's going to be helpful is if we take this in small bites, because nobody really knows how long this is going to be, and I think those who stay in contact with their creditors, even if it's a 2 month deal or a 3 month deal, the timing of it is much more likely to be successful than if you try to take eat. If you try to eat the elephant in one bite, you're gonna get well, it's not going to be pretty. How's that?
Yeah. So with landlords, trying to figure out a way to potentially at least pay the utility cost, their marginal cost of the property, and asking for potentially a deferment on the rent. And to your point, from their perspective, they could try to evict you, but if every restaurant in the city is shut down and every non-essential retail business is shut down, they can all get evicted, but it's not like they're going to be able to replace you with someone that easily.
Yeah, and I think the attitude, look, whoever puts on a robe, you know, you know, gets dressed in the morning and brushes their teeth and eats breakfast and we're all in this together. And if your approach is responsible, I think the attitude today is even even Congress is getting along, at least better than they have before, and there's some actual bipartisanship that's actually going on. Well, if there's a landlord that appears to be, I'm just using the landlord example, aggressive, or unnecessarily so, um, you know what? Judges judges aren't going to like that, and that's very different than if you just walk into an eviction hearing, shrug your shoulders, and say, "Corona, it's the Corona defense." All these bad things happened. Now the equitable balance of 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 what the legal rights are in today's world and how that changes those, not legally necessarily, but just from a humanistic standpoint, that's going to be a big difference. So I think landlords that are evicting businesses, I'm not sure what the benefit of that is, especially if there is some sort of proposal, because the courts aren't going to want to be hearing those today. I think in Michigan, by the way, for individuals, I think the governor uh, um, imposed, I think it was just yesterday, I believe, a moratorium on individual evictions. Landlord tenant, not business, but individual matters, and maybe some foreclosures as well. It's so fluid; it's hard to keep up. But uh, Over aggressive landlords are act at their peril. You have to give them a reason to look bad, if they decide to play hardball.
We talked about the landlords a bit. What about lenders, banks, and lenders? What kind of conversations should a business owner whose business is shut down be having with a lender?
That assumes someone's picking up the phone at the at the at the bank, or somebody is responding, because they are inundated, and the lenders have their own issues because their portfolios are in significant distress themselves. But the approach with the landlord, excuse me, with the lenders, um, you know, uh, again, it's all going to depend. But the lenders really don't want your assets. Obviously, they want to get paid, and there better be a good reason to look. Let me go back. If you take the payment holiday voluntarily, uh, not going to look so good. That may be, you may say to the lender, look, you know what, uh, uh, we're going to see what happens in the next 30 days. We'll be back to you then. I can't pay this month. And again, the small bite approach, because nobody really quite knows where things are going to go. Hard to give you a real specific approach. A lot of it depends on, were you current before, or are you 4 months in arrears? Not going to matter for the next month, but the attitude with the lender may be different. Um, Will, I also, if you don't mind, just wanted to mention something before we conclude, that I think is potentially helpful to your audience. Um, there is a brand new Small Business Reorganization Act, which became effective on February 19th. brand new, and certainly prescient. Congress normally isn't prescient, and I think this was not being prescient, but it sort of looks that way. So okay, um, this is an amendment to Title 11, and it's an amendment to the bankruptcy code. It doesn't repeal Chapter 11, but it's a new subchapter 5, and it is for small businesses in very, very important ways. The debt load has to be, when I say debt load, I mean a combination of secured and unsecured, all in liquidated secured and unsecured debts that are not contingent, um, of $2,725,625. If it is that or less, you are eligible. And what, in a real nutshell, this Chapter 11 for small businesses streamlines and simplifies and makes easier a business, the ability of a business to reorganize with a plan of reorganization that is filed within 90 days of the case, can be filed on day one as well. And it eliminates, by and large, creditor committees, generally speaking. Okay, there's no creditor committees. Equity can hold on to equity even though the creditors don't get paid 100 cents. Um, uh, it's an opt-in provision. It's brand new, and it allows businesses to get through a process with far less cost. There's no disclosure statement for those of you who are familiar with that in a Chapter 11, and it's a it's a time that it's a statute that is so timely right now, and it will enable many businesses to efficiently reorganize under this brand new statute. There's only a few cases that have been filed in the country, but I kind of like that because it allows us to to write on a whiteboard, and we can be the architect of many creative approaches, and I think it's something that is going to become very popular, and for very good reason.
I'm glad you pointed that out, Dan. We haven't talked about this part yet. Could you explain just what is Chapter 11 bankruptcy? You've mentioned it a couple times, but what does it entail? What do you need to prepare to go into it? How much does it actually cost for the professional services to go through it? Like, what is bankruptcy for people who are looking into the void and seeing that might be the path,
Sure,
one potential path? Like, what does it even mean?
sure. Chapter 11 is a tool mostly used by businesses, but it can be used by individuals uh, to restructure a balance sheet. And I guess let me give you the first piece of it. When you when a business needs time to and a breathing spell from its creditors, when this business, if there's a lender that is bearing down on you, or a landlord that has an eviction hearing, or many different reasons, above all, filing a Chapter 11 creates what we call an automatic stay. It is a big stop sign. It stops creditors in their tracks, by and large, from commencing or continuing um, uh, uh, their efforts to collect a debt. It stops, and it allows the business. Now, the business has to be able to at least break even during Chapter 11. It if it's losing money hand over fist, then something is going to happen, like a sale or an angel, or different investors, or equity needs to tap personal resources. So, but the point of the 11 is it gives the business the exclusive right to file a plan of reorganization for 120 days. It's 4 months where only the debtor gets to provide a plan. Of course, there's always exceptions here or there, but let's talk about the general rule, and that is, and it's pretty solid. Statutorily, there's 120 days, and during that time, this is Chapter 11. Above all, is a forum for negotiation. That's what it is in the big picture. It takes everybody and puts them under your tent and ties their hands for a period of time where you can negotiate, hopefully negotiate a consensual treatment of those creditors. And rather than the business showing up at trials in litigation and having to spend the time with trying to stay alive, it gives them a breathing spell and an opportunity. Now, Chapter 11 can be to reorganize where equity keeps equity, or Chapter 11 can be a liquidating process where a business is sold. Some of you may be familiar with Section 363 of the Bankruptcy Code. It allows a sale of substantially all of the assets of a business, free and clear of claims of creditors, and free and clear of liens of secured creditors. And many times that is a good way to sell a business. Maybe the owners want to get out, and the bank is not going to renew a loan. You can have a very robust sale process in a Chapter 11, uh, and focus on maximizing value of the collateral and value to the estate rather than running around and trying to put out fires here and there. So it's a very, very useful tool. And the the real successful cases, or the more successful cases, are ones where you do the homework and the hard work in the beginning. You don't file and say, okay, well, gee, I got time now, and figure it out later. You try to, sometimes you can't help it, but you try to figure out as much as you can going in, so you have a game plan and the steps that you take are all consistent and point towards achieving the game plan or game plans that you are focused on. And by the way, in case someone is wondering, it is not either or. You can file a Chapter 11 to reorganize and decide in the middle of the case or sometime later, you know what, I think we need to liquidate. So you can, it's a very flexible tool, but above all, it's a forum for negotiation.
What's sort of the range of what a smaller business should be expecting that this is going to cost in terms of professional services? I'm sure it's a wide range, but just sort of 80% interval if we're talking a business with, 3 to 10 employees and its revenues are, in the low millions perhaps. Just what would your typical guess be? Does it even make sense for a business that size to go into bankruptcy? Or like what does it cost roughly?
Yeah. Let me focus on my crystal ball, because it's not always that clear, and I don't mean to be cavalier about it, but much depends on the attitude and the actions taken by the other parties in the case. Okay, if 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 you can get everybody under the tent and it's efficient, and it's a small business, and things go the way that you're hoping they go, then the cost of an 11 is, it could be as low as $20,000, $25,000. Now, that, and some of that is paid in a retainer, and some of it is paid over time. Um, Uh, if you wind up with lots of fights and lots of court time, you're talking, could be substantially more than that. But the key here is to pick the battles that you really need to fight and be very selective on who you marry and who you fight with. Uh, so, um, but restructuring professionals will work with the clients so that they can afford a retainer and also get paid throughout the case. Sometimes they work out, sometimes they don't. But it's flexible, um, and it really just depends. It's a great question, and I wish I could give you, a rule of thumb, but the key is that you have communication with your professional and you see how the case goes.
Hmm.
And if you trust the professional, and there's good communication, things may happen in the case where you talk to the client, say, you know what, this this is going to get too expensive and it's not going to get solved very well. Let's do something different. Okay, so it really depends on many factors.
Yeah.
Um,
You mentioned one thing, which is that the business, at least on a marginal or variable basis, has to be breaking even during the course of the bankruptcy proceeding. So, is that even an option for a business where, just because of the pandemic, the doors have been shut and they have no revenue at all?
yeah, very good. I'm glad you mentioned that. Um, by the way, and let me get a little more specific on that comment before, because I can understand how it may be it may have been too broad. There's got to I'll talk generally and then answer your specific question. Um, a business can lose money in Chapter 11. It just has to have an end game where there's going to be a solution, or at least an event that is reasonably designed to create the business's ability to to uh, to make a payment proposal on the antecedent debt. So sometimes a business loses money in an 11. Happens quite a bit, but there's got to be a rational story and approach to how that is going to stop. Now, specifically to your question, we'll use your restaurant example. Uh, the 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 governor just said, no, other than carry out, you can't, restaurants are closed. Well, of course they're losing money. And many businesses are going to be losing money. I think the attitude and the temperature in these cases is going to adjust accordingly, because when if these businesses have to file, I think if they're responsible and if they are proactive, they're going to get uh, uh, all the benefits of the doubt that they're entitled to, and probably some more, um, in the general scenario, because this is affecting everybody. I think there will be understanding and relaxation and lateral give and take, um, by the court system, and it ought to be by the creditors, because this is nobody's fault. Uh, I think the point here is that uh, 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 businesses are going to get an extra bite at the apple, or a few bites at the apple, more bites at the apple than they ever would before, because this isn't a situation where the owner of the business decides to buy a boat when that cash needed to stay in the business. I just use that as an example. The bankruptcy trustees love to find boats, and they seem to be demonstrations of excess that don't play very well, in the courts. So that's just an example. But the idea here is there's plenty of. I think if you do this right, you can buy a lot of time.
That's really encouraging to hear. And I have one final question about leases. So, if a let's say, I mean, a restaurant even could be doing delivery, but let's say like a a bar or a nail salon that's totally shut down. If the owner has let's say a 5-year lease agreement, what typically happens? Is it possible to get out of those lease agreements? If the business does just decide to shut down entirely and kind of go out of business, is it are typically the owners able to get out of those lease agreements through some force majeure type clause, or are they going to be personally on the hook to pay the rent for the next 3.5 years?
Are you talking about a situation where an LLC or a corporation is the tenant, but the landlord was able to get a personal guarantee by the owner or the member? Is that your question?
Yeah, that's the question, which probably I would guess might be a common thing for smaller businesses, a dry cleaner, a yoga studio, a nail salon. The owner might have had to sign a personal guarantee since the business didn't really have any significant equity.
Yeah. Well, query whether that personal guarantee is worth anything in the first place, because typically small business owners, franchisees, many times, they put that they are highly illiquid, and if they have started a small business with an SBA loan, a 7A or other SBA products, and they have pledged, granted a second lien on real estate, and have given guarantees and collateral to the SBA lender, they're likely uncollectible anyways for a landlord, but or for a lender. But in your situation with the space, I don't think I think the zeitgeist of the times right now. I don't I don't I don't think a tenant that is a tenant is in communication and cooperative with the landlord and doesn't play games and doesn't hold on to keys and doesn't start pulling stuff out that did not become a fixture, or if it did become a fixture, excuse me. If there's a run on the space and you really tick off the landlord, okay, now you've bought yourself a fight. But I think the likelihood generally of a responsible tenant, even with a personal guarantee, having to pay that guarantee is generally quite small, for all of those reasons. And on top of the fact, the landlord that is maybe having issues with other properties has to decide where it wants to spend its money. It's got space to try to refill, and there's going to be a glut of space on the market. So the personal guarantee issue is generally pretty solvable.
All right. Well, Dan, we've gone past the hour. This has been hugely informative to me. Where can people find you if they wanted to follow up with your firm? What's the best place for people to find you?
Well, I'm our office is open optional. People that feel comfortable working at home can work at home. People that feel comfortable in coming in could come in. That may change depending on what happens. But here's the key. I'm awfully available. Do you want contact information? Is that what you were looking for?
It's up to you, Dan. Do you want to give a website, or what's the best place if people wanted to find out more about your firm? And
Yeah. Please look at the website, www.schaeferandweiner.com. Schaefer, Schafer, and spelled out Weiner, Weiner.com. My email is dweiner, the initial D, Weiner, at schaeferandweiner.com. The general phone number is 248-540-3340. And all calls are being processed and routed accordingly. And if it's easier to call, fine. If it's easier to email, fine. If you want to meet, you can be at one end of the office and I'll be at the other, but I'll meet with you.
Dan, you're extremely, extremely generous. for sharing your experience here on this call. Thank you so much. Listeners, you can, we are working at Umbrex. We have 100 volunteers working to build a pandemic playbook with a checklist for small business owners. You can visit umbrex.com and click on the pandemic playbook link. We're looking for volunteers to serve as coaches or consultants pro bono to small businesses. And we're also welcoming small businesses that are looking for help. You can, to get some pro bono consulting, you can click on that link as well. So, Dan, I'll include your link to your firm in the show notes, and thank you so much for joining.
Pleasure. I enjoyed it, and thanks for the opportunity to help.